ongoing problem that is still there despite the amount of time that's passed. He does not require the medical care from a psychiatrist or psychologist, but I would suggest that that's still significant. Consequently, we would suggest taking into consideration the medical bills, the loss of earnings, and the medical and or psychological negative effects upon Mr. Nieto, a award of $150,000. And that would be all inclusive, obviously, of medical bills, pain and suffering, lost income.
Well, counsel, let's have a little back and forth now.
Sure.
So according to your motion for default judgment, it looked like you were requesting special damages in the amount of $13,697.61. My guess is, based upon the testimony that was before me, that is the total of the medical bills. Is that correct?
Yes, Your Honor.
Okay. And then the testimony I have before me is lost wages of $20,000 approximately, correct?
Yes, Your Honor.
Okay. So help me understand. So let me just, I got a calculator up, and I definitely encourage everyone to double check my math, because I went to law school and went the criminal route because I didn't want to do math or billable hours.
Yep, my daughters remind me of that fact, Your Honor. They're both, one's in college and one's in high school, and they both remind me of the fact of law school instead of math background or background versus law school. But anyway, I apologize.
No worries. So the $13,697.61 plus the lost wages of $20,000 comes to $33,697.61.
Yes.
Help me understand how we get to the, I guess, round, I'm going to use some round numbers here, get to that 115 to get to that 150 mark. We haven't, and I know you're also requesting your cost for $395.52. So help me understand how we're getting to that rest of the amount based upon the testimony. And again, I have no exhibits before me. Nothing was admitted. I'm just based upon the testimony.
Well, based on the testimony, Your Honor, obviously the pain and suffering is that element, and it would be the fact that he still has a permanent scar, and what he, other than the specials, which I would say are hard specials, the medical costs and the not quite as hard medical loss or consequences of loss of income, those are pretty straightforward. But admittedly, the pain, that would be the pain and suffering, and based on his testimony again, and the constant reminder of having to go through that, the constant fear that he's feeling now, not to overemphasize that, but certainly not to diminish it, that's where that would come from. And it's certainly not I wish there was a calculator we could use to say X times X. I know plenty of clients want that kind of calculation, and it simply isn't there. I base that on collective experience representing people with injuries, and admittedly, I'm a bit biased. I know Mr. Nieto, and I know people that have been injured and gone through it and suffered through it. So I tend to look at the value in that through those glasses. However, I would also base that on if we were in a jury trial setting, I think that would be in the range, maybe that be on the optimistic range, but I certainly think that would be in the range of what a jury might reasonably allow for pain and suffering for what he's been through, and he's still experiencing, still has on his face. Admittedly, it might go the other way a bit on the pain and suffering, but I would argue that clearly the attack was unprovoked. There's liability. He clearly was hurt. It's just a matter of, clearly he has the bills, the lost wages, and it's a matter of the pain and suffering. And this is an abbreviated hearing, not being able to see Mr. Nieto. And again, my direct examination was rather abbreviated also, but based on what I would anticipate at a jury trial, if it were in front of a jury, and or that's where my calculation comes from. Okay. Hopefully that answers your question.
It does. Any other argument or anything else you want to present? I mean, this was set for an hour. I mean, it's only 4:04, so I want to make sure you have enough time to present whatever you want to present, counsel. So
no, Your Honor, I know you reserved an ample amount of time to this, but we never know quite in advance what might happen. and connecting is not an unusual issue, despite everyone's best efforts. But no, Your Honor, I appreciate the offer, but we presented all the information that we wanted to present and laid out the facts. And I know I could move to have the exhibits admitted, go through the steps of having them admitted, but I don't No, under these circumstances, if you require me to do that or would want that, I mean, I could move to have him exit entered now. I mean, he's given testimony as to the bills, as to the other records of places he went. I could, I apologize if I'm doing this at the end versus along the way, but again, I look at these hearings as kind of I defer to the judges in these matters because they can go, if there's no one on the other side, many times it's pretty straightforward and it's a matter of evaluation of the case.
Understood. But again, as you know from the case law, that default hearings are obviously one-sided based upon the nature of the default. But default hearings are not just mere rubber stamps of whatever the appearing party is. So this is why,
certainly.
Again, I encourage everyone to review my work, double check my math, as I joked earlier, and also I want to make sure that if anyone takes a look at this hearing or this transcript, that everyone has a full and fair opportunity, and both sides, whether present or not, are considered fully and fairly. So that's why I'm offering you, Mr. Johnson, an opportunity to introduce and make any further arguments. So.
No, I appreciate that, Your Honor, and I fully appreciate the fact that even though there isn't someone on the other side, we want everyone, should they come back and look at this, to certainly say, hey, this was above board and it wasn't just us coming in throwing out a number without anything to substantiate it and having the court award it in that effect. I wouldn't expect that from the court, and hopefully we've prepared and presented everything we want to do. I appreciate that extra opportunity to do that, Your Honor.
Well, fantastic. So let's start from the beginning. The original complaint was filed on May 16 of 2025. Is that correct? I got my notes.
I believe so, Your Honor.
Yeah, May 16, 2025. I show Betty Villa and Tony Villa Jr. were both served on May 20th, 2025 of that original complaint. Thereafter, you filed an amended complaint on June 24th, 2025. And upon my review, it looks like it was just added some defendants that were subsequently and ultimately dismissed. So it didn't really change anything with the two remaining defendants, Betty Villa and Tony Villa. Okay.
That is correct, Your Honor.
All right. And then there was the applicant, but there's no answer or other defensive filing filed by the two remaining defendants, Betty and Tony Villa Jr. You filed your application and affidavit of default against both of those two defendants on May 20th of 2026. I'm going to slow down for the benefit of the court.
Yes.
And again, there was no answer or otherwise defensive filing filed within the allotted 10 business days.
This is correct.
So therefore, I do find the defendant, Tony Villa Jr. and Betty Villa, are in default. Based upon the default, the well-pled facts of the complaint are deemed judicially admitted. We've had today's hearing where I took and carefully considered the evidence presented in the form of Mr. Nieto's testimony. What I have in my notes is that he was attacked unprovoked by the defendant's pit bull dog. It bit him in the foot, the hand, and the face. And he required medical attention of stitches, cleaning and pain medication, and then follow-up to remove the stitches. The testimony is that the scarring is still visible. However, Mr. Nieto also testified quite candidly that no one has really commented upon his physical scarring. He also was unable to work for approximately 3 months, and the uncontested testimony is that of approximately $20,000 in lost wages. The medical bills from the medical attention that I mentioned a few moments ago is $13,697.16 based upon the testimony. And then I'm also cheating to get that exact amount from the motion that counsel filed back on June 19th. Also, it's in the marked but not admitted exhibits. Mr. Nieto testified that he does experience unease at the park. He is currently scared of dogs or worried about dogs based upon the attack. He also testified that he did not really miss any time with family or friends based upon the attack. He also testified that, I believe, to kind of summarize, that he is a little not a little, he is not at ease when he's at the dead end, which I believe is where he testified the dog attacked. So I do find that the medical bills, the specials, as counsel's been calling them, and the lost wages of $20,000, that's appropriate. The pain and suffering, I'm having a hard time getting to that full request of $150,000. I mean, being bitten on the foot, hand, and the face area is certainly disconcerting to bury the lead. But based upon how Mr. Nieto's statements that he is not, no one's commented upon the facial scarring, and then while being at ease based upon that is certainly traumatic, there's no evidence of how that unease is really physically manifesting. So I'm not going to award the full requested amount of $150,000. I do find, based upon everything, the generals of the emotional and psychological injuries, the special of the medical bills, and the statement of costs, I think the number that I have that I believe is fair for a grand total of everything is $75,000, counsel.
I understand, Your Honor.
One bit of housekeeping, counsel. I do not have a proposed form of judgment. Can you lodge something for me?
Yeah, absolutely, Your Honor. I'll have that prepared and send it over to you immediately.
Okay, and I believe just to kind of speed things up, I mean, I recognize it's 411. If you want to email it to my division staff at NEC02, Miguel, my assistant, who just put it in the chat, that's the good email address if you want to just email it over to the division that way. But I'll give you until the end of business tomorrow to do so, because it's 411 and I understand the practice of law, especially on a Friday.
Thank you, Your Honor. I appreciate that. Hey, could you post that one more time in the chat? I was going to take a quick, just a old-fashioned, take a screenshot of it very quickly. I saw it pop up. There we go. Perfect. Thank you.
So, okay. Does anyone else have anything else they wish to